Good afternoon, everyone. How's everybody doing today? We hope everyone is safe. As we all know, it's been a month since this enhanced community quarantine was implemented. Because of this, almost all of the private establishments were required to cease their operations, or if allowed, were only allowed to do so through skeleton force. These rules are actually causing issues in the labor sector. Indeed, it is the intent of GSMH law to keep our clients abreast of the legal updates and developments as regards to this. In fact, we have actually sent out a legal memorandum with an attached compilation of DOLE issuances. GSMH law, however, figured that there may be other ways for the clients to be updated. Hence, this webinar. This webinar is actually a brainchild of GSMH Law's partners, and one of them is Attorney Rodolfo San Diego. Attorney Rodolfo San Diego is one of the founding partners of GSMH Law, whose specialties include business and commercial litigation. And today, Attorney San Diego is with us to have his opening remarks.
Yeah, good afternoon, everyone, and thank you for attending our webinar on the implications of on labor of COVID-19 and the continuing efforts by the government. Thank you for your introduction, Bianca. I am Rodolfo San Diego, one of the partners of GSMH Law. As Bianca told you earlier, this was a brainchild of the partners to inform and aid our clients and friends navigate the continuously changing legal and economic landscape brought about by this pandemic. We cannot downplay, as we ourselves have been affected by the daunting challenges for businesses right now. But it is our hope that our firm, through this webinar and other efforts that we're undertaking right now, may be able to inform and assist you in mitigating the effects of the pandemic on your business and on your labor force. I would like to issue a usual disclaimer. As you might expect, this webinar and the opinions expressed by our staff, by our legal panelists are informational in nature, and the examples we will give are only for illustration purposes only. In order for our firm to properly advise you of the legal implications specific to your establishment or concern, we would need to be fully apprised of all the attendant facts and circumstances. If you have concerns that may not be covered by this webinar, or you would like to inquire how to execute any of the mitigation plans or remedies that will be described during this session, we would encourage you to send us an email through counsel@gsmhlaw.com or through the emails of the lawyers and the personalities who will speak today. The emails and contact details will be flashed later. And with that, I'd like to give my thanks again, and I will turn over the floor to our panelists, Mel, Kimi, Bianca, and Jaline. Thank you.
Thank you for that, Sir Attorney San Diego. Of course, this webinar will not be possible without a moderator who will facilitate the webinar and the main speakers who will discuss the labor issues arising from the enhanced community quarantine. The moderator will be Ms. Jaline Nostratis. The main speakers will be Attorney Melchor Manalo and Attorney Christine Declaro. To start the webinar, I will give the floor to our moderator, Ms. Nostratis, who will discuss this webinar's house rules.
Thank you for that, Bianca. Good afternoon, everybody. Welcome and thank you for joining us today. First, a couple of house rules that we must keep in mind in order to facilitate an orderly webinar. Number one, participants other than the panelists are muted. If you wish to ask any questions, please type in your questions in the question and answer portion icon below or at the bottom of your screen. I will monitor the questions throughout the presentation and I will post them one by one to our speaker at the end of each topic. Follow-up or additional questions may be asked and will be answered at the end of the presentation during the Q&A portion. Since we have so many people on today, we may not be able to answer all your specific questions, but we will do our best to pick up questions that are hopefully representative of your concern. We are also available for follow-up, and for that, we leave our contact details at the end of the PowerPoint. Lastly, we will provide you materials such as the PowerPoint of this presentation, and we will send those to your respective emails. Please expect them shortly after this. Bianca?
Thank you, Ms. Nostratis. Now, without further ado, I will give the floor to Attorney Manalo to start his discussion.
Yes, thank you for that, Bianca. Ladies and gentlemen, good afternoon. I'm Attorney Melchor J. Manalo, Senior Associate at JSNS Law Office. I will be discussing today the labor implications of the enhanced community quarantine. Bear with me so that we can show the slides. There. My presentation will focus on 3 points. First being is that the condition and status of employment, the types of flexible work arrangements and its implications on the status and conditions of employment, as well as the payment of compensation during this enhanced community quarantine, including the payment of 13-month pay and holiday pay will focus on this item. As we all know, the enhanced community quarantine was made effective through a proclamation issued by the President. It was dubbed as Presidential Proclamation number 929, as enhanced by the memorandum from the Office of Executive Secretary on March 16, 2020. This was enhanced and extended up to April 7, 2020, up to April 30, 2020. Now, during this enhanced community quarantine, as we all know, the mandatory home quarantine for everyone is being enforced. The mandatory temporary closure or shutdown of all private establishments in Luzon, except in certain exceptions or establishments, are being enforced. As of now, there are a lot of regional and provincial governments that have imposed a similar enhanced community quarantine. Now, during this enhanced community quarantine, we have to inform ourselves of what are the do's and don'ts. No? For the do's, of course, everyone must stay home, except only for those emergency purposes or for buying necessities. As for the don'ts, of course, no, there shall be no classes at all levels, and there shall be no reporting for work in government and in private sectors, except for some exceptions. The public transportation is temporarily suspended as well. Now, the employers are also encouraged to adopt a work arrangement that will not require physically reporting for work. Employers should extend financial help or assistance to their employees and may grant prorated 13-month pay. Take note of the word, this is only may. No? This is not, we are not using the term shall. No? This is merely encouraged by the private government. The Department of Labor and Employment, as well as the Department of Social Works and Development, will also provide social amelioration packages for those affected by the work stoppage. As of now, the Department of Labor through the public to the POEA will also enforce will also observe the give amelioration packages to our OF distressed land-based and sea-based workers. Unless the company is engaged in basic necessities and for services, employers should not require their employees to report for work. Employers should not terminate their employees by reason not only of reporting for work because of the COVID-19 situation. Now, what are these establishments that are allowed to continue their operations? Basically, there are only two types of companies now. We have the essential establishments and the non-essential establishments. When we say essential establishments, these are the establishments which provide basic necessities and such activities related to food and medicine production, such as public markets, supermarkets, groceries, convenience stores, hospitals, medical clinics, pharmacies, energy, telecommunication supply facilities, drugstores, food preparation delivery services, water refilling stations, the manufacturing and processing plants of basic food products and medicines, banks, money transfer services, power and water. Essential establishment also include those businesses relating to business process outsourcing, the export-oriented industries, and capital markets. Now, if you are part of the essential establishments and you continue to operate within this enhanced community quarantine, we should observe the following. Number one, there should be strict implementation of skeletal workforce to support the operations, s- strict social distancing measures, and our flexible working arrangements. Now, for BPOs and export-oriented industries, the personnel must be allowed or must be provided with appropriate temporary accommodations. The transit to and from essential establishments are allowed anywhere within the ECQ area. The security personnel is also allowed to travel within the ECQ area. Now, for the non-essential establishments, you are required to temporarily close your physical offices. When you say temporary close your physical offices, the ECQ the government will not stop you from operating through the flexible working arrangement that we will discuss later, such as the work from home and other alternative work arrangements that is allowed. Now, when we say flexible working arrangements, this is defined as an alternative arrangement or schedule other than the traditional or standard work hours, work days, and work week. This includes but is not limited to telecommuting or work from home, which basically means that the employee renders remote work such as work from home arrangement. The reduction of work days or work hours, meaning the normal work hours or work days like schedule, for example, only the employees will be required to work only during MWF or TTHS from 8 to 5 p.m. For the reduction of hours, all employees will be required to report for work from Monday to Saturday, for instance, from 9 a.m. to 1 p.m. only. This corresponds to reduction of workday as well. For the rotation of workers, the employees will rotate work or alternately provide work within the week. For example, the employers will divide the employees between Group A and Group B. The Group A will only render work from or will only report for work during MWF, while Group B will render work or report for work during the TTHS. No? For the implementation of forced leaves, employees are required to go on leave by utilizing their leave credits. It is important to be informed that to note that these are voluntary arrangements aim to cushion or mitigate the effect of loss of income. The employer and the employee are primarily responsible for the administration of such flexible working arrangements. And in cases of difference in opinion, the grievance machinery in place in the company will be used. Now, in cases of inadequacy of grievance machinery or there is no such machinery in force, such grievances or such issues will be referred to the Department of Labor for conciliation process. This is normally done through the filing of ordinary complaint. Now, as I mentioned earlier, these flexible working arrangements is not inclusive. As long as there is a meeting of minds, there is an arrangement between the employer and the employer, the employers may enforce such alternatives. For example, a hybrid of working from home with reduced work hours or a working from home with rotations. Now, for the implementation of this flexible working arrangement to be valid, the following must be observed. The employers and the employees must meet to explore must meet to explore and adopt flexible working arrangements. Number two, a copy of Labor Advisory Number 9 shall be posted in conspicuous location in the workplace. Number three, notify the DOLE, Department of Labor, through its regional, provincial, or field office, which has jurisdiction over the workplace, using the establishment form on COVID-19. And lastly, the employers are required to submit to the Department of Labor at least 1 week before the implementation. Now, with regard to this notification, the employers should still file their notice. I understand that some of the companies are already enforcing the flexible working arrangement without filing of this necessary form. According to the Department of Labor, Even if you are already enforcing or observing a flexible working arrangement, you should still file a certain notice, that required notice before the Department of Labor, or the 1 week period is deemed prejudicial. Now, if the flexible working arrangement, if the 1 week notification is you think is prejudicial to your company, meaning you cannot wait for that 1 week, you have to file that notice explaining why is it prejudicial to you, or why is the 1 week period should not be observed. So meaning you just have to justify it. Now, flash on your screen is the establishment report on COVID-19, and it is required to be filed before the Department of Labor Employment. Now, one of the things that is now in place is the work from home arrangement. It is facilitated through a telecommuting program of telecommunication tools and computer technology. It is an arrangement which allows the employees to work in an agreed alternative workplace and submit their deliverables through a telecommunicating program or telecommunication tools and computer technology. If you are already observing a work from home, these policies may be applicable to you. If you're already enforcing this, the mandatory legal benefits will be applicable. The workplace standards also applicable. The training and career development of your employees is also applicable, and the exercise of collective rights. However, such incidental conveniences of the employees will not be applicable during this in this work from home implementation. For example, the required internet speed, or having a brewed coffee, or if your companies are enjoying a free lunch during the normal working operations, then this may not be applicable for such an arrangement. To give you an example, the GSMH Law Office has been observing a work from home from March 17, 2020. In our work from home policy, there is no change in our salaries and benefits. The personnel are required to ensure continuation of high quality and work, and that the well-being of all personnel is also being closely monitored. Now, to ensure that we are working, certain parameters are being enforced by the partners. No? For example, there should be prompt responses to clients' queries. There should be high level of output. There should be the lawyers should be always available for teleconference, and that all are required to submit their daily service records. Now, forced leave. Forced leave is, of course, a leave of absence during the community quarantine period, which shall be charged against the worker's existing leave credits, such as vacation leaves or sick leaves, if any. The remaining unpaid leaves during the said period may be covered and may be subject to the conditions provided in the Department of Labor's proposed COVID-19 Adjustment Measures Program, or the CAMP. This will be discussed further by my colleague, Attorney Kimi Declaro. For an example, an employee has 10 remaining leave days at the start of the quarantine period. In that case, the employer has to pay the employee's wages for those 10 days. Only then can the employer start deducting pay for days not actually worked. Now, let's say, for instance, that if the employer will continue its operations, but the employees are unable to perform work during this enhanced community quarantine, then the no work, no pay policy shall be applied. The employees, however, may choose to use their leave credits. One of the things that are being questioned right now is the status of the employment. No? Those regular employees who stay within the work premises or fail to render work are still considered as regular employees. The status of the employment is not affected or subject to change as a consequence of a declaration of a state of public health emergency. Hence, employees should still be treated as such before the COVID-19 pandemic. With regard to probationary employees, during this enhanced community period, they shall continue to be treated as probationary employees or trainees. The 1 month ECQ period hopefully will not be extended to 2 months, will not be counted as part of the 6 month probationary period. These probationary employees may be entitled as well to the camp financial assistance. However, it should be noted that this principle of 1 month period should only be applied to those companies which did not continue their operations. If you continue your operations and the probationary employees continue to render work, whether it be work from home or a rotational basis, then the period of work days will be counted in the 6 months probationary period. Principle of no work, no pay. The employers are not obliged to pay employees who did not render work during this enhanced community quarantine, unless there is a company practice or policy or collective bargaining agreement otherwise provides. The employers may also reduce compensation based on the actual work performed by the employee unless an agreement or company policy provides otherwise. In case of reduced regular working days or to prevent serious losses, employer may deduct the wages corresponding to the days taken off from the work week. Now, if the employer has given salaries to those who did not render for work as a form of financial assistance, then this financial assistance can be considered as a gratuity, meaning subject to management prerogative and can be unilaterally withdrawn or reduced. The reduction of such financial assistance will not violate the rule on non-diminution of benefits, as long as it did not ripen into company practice. However, in such cases, to avoid such misinterpretations and confusion, we recommend that before you give such financial assistance, the purpose of giving out such financial assistance and the duration should be specifically specified. With regard to the payment of 13-month pay, the employers are merely encouraged to grant employees their 13-month pay. As we all know and as we all have heard, the Department of Labor and Employment as well as the President has been asking those companies, especially belonging to the large sectors, to already pay in advance the 13-month pay. Again, this is just merely encouraged, but is not mandatory uh, on the part of the employers. Because under the law, all rank and file employees in the private sector are only entitled to receive the 13-month pay on or before the December 24 of the year. Except, of course, there's an existing company policy of giving out their 13-month pay in the middle of the year, for example, June or in May. If there is such a company practice and if you continue to observe that, then you should pay the 13-month pay. The computation of 13-month pay should not be less than 1/12 of the total salary earned by an employee within a calendar year, regardless of the nature and employment. This is the more interesting part, the payment of holiday pay. No, we have observed 4 non-working holidays during this enhanced community quarantine. We have the Araw ng Kagitingan or Day and Valor and the Holy Thursday on April 9, the Good Friday on April 10, and the Black Saturday as being a special holiday on April 11. Now, with the payment of holiday pay, the employers are allowed to defer payment of holiday pay on April 9, 10, 11 until such time that the state of emergency ceases and operations of the establishments has been normalized. However, for those establishments which have totally closed or ceased their operations during this enhanced community quarantine period are excused from paying their employees the mandated holiday pay. Now, flash on your screen are computations of the holiday pay. No, what the more interesting is the April 9 being a double holiday. Uh, if the employee reported for work on April 9, then he shall be entitled to 300%. But you should note that this payment of holiday pays will only be made applicable if the employee reported for work on the day prior to the effectivity of the enhanced community quarantine. Meaning if they reported for work on March 16 or they are on paid leave on March 16, then they shall be entitled to this holiday pays on April 9, 10, and 11. That ends my first presentation, first part of my presentation. I will be entertaining certain questions.
Yes, thank you, Attorney Mel. Before we proceed to our next topic, let us first entertain some questions from our client. So this is a question from Mr. Bon Jeffrey. Attorney Mel, are the FWA exclusive from one another? Can an employer apply one or two FWA formats or arrangements?
You mean flexible working arrangement?
Yes, yes,
Okay.
Attorney.
As I've mentioned earlier, the employers and employee can enter so long as there is a meeting of minds, there have been agreement, there's been a consultation between the two, there's been a proper notification, and there's a posting of notices. They can employ a hybrid of this flexible working arrangement. For example, they can employ, they can observe a working from home with reduction of workdays or working from home with rotational set of employees. This corresponds to reduction of salaries as well.
All right, sir. This one is from CL Ramos. Attorney Mel, is there a need to extend the probationary employment agreement or is it automatically extended for the length of the ECQ?
Okay, let me clarify now. If the probationary employee did not render work during this enhanced community quarantine period, then there is no need to, regardless of their work or not work, then there is no need to execute another probationary contract. But if they rendered work during this enhanced community quarantine period, then the 6-month probationary period will still apply to them.
This one is from an anonymous attendee. Sir, Attorney Mel.
There's such?
Yes. Attorney Mel, April 9 holiday pay is at 200% due to double holiday, right? So
If
is this
unworked,
rate,
right?
yes, sir. Is this rate applicable to supervisors and up or only to the rank and file employees?
Unfortunately, this only applies to the rank and file employees. You know, the supervisors and the managerial employees are not entitled to such a holiday pay.
Attorney Mel, follow-up question is, are the supervisors and ops or the managerial employees entitled to the 100% holiday pay and not to the 200%, correct?
Yes, yes, that's correct. They're entitled to 100%.
More questions from Mr. Bon Jeffrey. May the employer apply leave credits of employees similar to forced leaves, although the employees are also following the work from home arrangement?
They cannot, no. If they are observing a work from home and they are already rendering work during this period, then their leave cannot be untouched, no. I mean, they cannot be utilized. However, if they observe a hybrid type of schedule, for example, if they will just render work during MWF, then their leave credits will be utilized for the Tuesdays and Thursdays.
From Ms. Mary Grace O'Connor, regarding the holiday pay, for manpower agency, are they obliged to pay the holiday pay if their clients where the employee is deployed do not operate?
I'm sorry?
For manpower agencies, are they obliged to pay the holiday pay if their clients where the employees were deployed are not operational during the ECQ?
The principle of no work, no pay shall be applied. No? If such employee did not render work, then he shall not be entitled to, they shall only be entitled to such mandatory payment of the holiday premium, regardless of whether they are contractual employees or not.
Attorney Mel, another question on holiday pay. So from Tony Mendoza, just to clarify on the holiday pay, we are closed right now. So are we excused not to pay the equivalent holiday pay?
Okay, if you have temporarily ceased your operations and you have filed such certain notice before with the Department of Labor and Employment, then you are excused from paying the holiday pay.
How about this, Attorney Mel, from IQ Packaging? Probationary employee was not able to report for work due to the ECQ. However, our site is operational. Will the probationary term be extended?
Extended?
Yes, sir.
Okay. If you mean the company is already in operation and uh, the probationary employee refused or cannot report for work because of COVID-19, is that a question?
Yes, sir.
Okay. Then the principle of no work, no pay shall be applied. And if the reasons really COVID-19 related, then the extension of the 6-month probationary period will also be applied as well.
Attorney Mel, from another anonymous attendee. Can we implement no work, no pay for monthly paid employees? We are right now on reduced work hours and work week.
Okay. Let me come again. Can you repeat that question?
Can we implement a no work, no pay policy for monthly paid employees? We are on a
Yes,
reduced work hours and work week.
Yes, you can.
All right, sir. Let's proceed to our next topic. We will entertain your other questions during the Q&A portion. Thank you. Please keep them coming.
All right.
Attorney Mel.
Now, the second part of my presentation is the possible recourses of the employers. No, these are the temporary closure or cessation of business, retrenchment, and permanent closure or cessation of business. Okay. When you say temporary closure or cessation of business, it is defined as a complete or partial cessation of the operation and or shutdown of the establishments of the employer. This is provided expressly under Article 301 of the Labor Code. This is a mandatory closure of all as of now, there is a mandatory closure of all private establishments in Luzon, implemented from March 17 until April 30, 2020. However, the Department of Labor itself mentioned that due to the uncertainty caused by the COVID-19, the closure may extend from a month to 6 months. No? Now, during this temporary closure, it is important to note that the employees' leaves will not be utilized. However, during this temporary closure or cessation of business, this shall not prompt the companies to dismiss their employees, unless, of course, there's a justifiable cost leading to such a layoff. However, after 6 months, the employees should either be recalled to work or permanently retrenched. Otherwise, they shall be made liable for illegal dismissal. Now, for retrenchment, it is an act of the employer of dismissing employees because of losses in the operation of a business, lack of work, and considerable reduction of the volume of the business. For this retrenchment to be valid, the following requirements should be observed. The retrenchment should be undertaken to prevent substantial, serious, actual, and real losses, which are not merely de minimis, or if only expected, are reasonably imminent. No? Service of written notices both to the employees and the Department of Labor at least 1 month prior to the intended date of retrenchment shall also be observed. There should also be a payment of separation pay equivalent to 1 month pay or at least 1/2 month pay for every year of service, whichever is higher. No, there should also be a use of fair and reasonable criteria in ascertaining who would be dismissed and retained. And lastly, this is the most important, retrenchment should be undertaken in good faith. Now, retrenchment can be applied to probationary employees as well. However, these certain rules and guidelines should be followed, and the principle of last in, first out policy should also be applied. For the permanent closure or cessation of business, the following requirements should be observed. There should be a service of a written notice to the employees and to the Department of Labor at least 1 month before the intended date thereof. The cessation of business must be bona fide and real in character, and the payment to the employees of termination pay amounting to 1 month pay or at least 1/2 month pay for every year of service, whichever is higher. Those three are the only recourses of the employers as of now.
Hi, yes. Attorney Merrill, right now there are no questions regarding retrenchment. If you have any questions, kindly place it to them in the Q&A icon at the bottom of your screen or in the chat box at the rightmost portion of your screen.
All right, thank you.
Thank you.
Shall now proceed to the third and final point of my presentation, which is the effect of the enhanced community quarantine to the social welfare legislation, such as the SSS, Pag-ibig and PhilHealth, social amelioration, and financial assistance programs. The DOL-ACAP COVID-19 adjusted measures program will also be part. But as I mentioned earlier, the CAMP will be discussed further and in full by Attorney Kimi Declara. For SSS, the SSS, has the SSS, PhilHealth, and Pag-ibig have imposed several advisories, and resolutions discussing or involving these enhanced community quarantine. For the SSS, for instance, the UMID card applications has been temporarily suspended until April 30. The payment deadline for the first quarter 2020 contributions of self-employed, voluntary, and non-working spouse members has been extended as well until June 1, 2020. The requirement for the annual confirmation of pensioners or ACOP program has been temporarily suspended until April 30, 2020 as well. For the deadline of the filing of sickness notifications and sickness benefits claim has already been extended as well. For the employed members and employers after end of confinement, or for employees and after receipt from employee of such employers. Now, for the self-employed or voluntary members or the overseas Filipino workers, they shall be extended until the end of the confinement. Now, if you would notice, the extensions has been made up to April 30. These resolutions were made prior to the extension of the enhanced community quarantine. So we will be expecting more advisories maybe for the extension of these payments. For the Pag-ibig, there is an availability of multi-purpose loan and calamity loan. There is also a 3-month moratorium on all Pag-ibig fund loan. The loan payments from March 16 to June 15 are hereby extended. This corresponds to the extension of 3 months of your existing payment schedules as well. With regard to Pag-ibig housing loans, the Pag-ibig has also imposed a 3-month moratorium. Now, this 3 month moratorium is automatic if the payment is up to date, no, as of March 16. But if the payment is not up to date as of March 16, then it shall be subject to prior evaluation. There is also a 3 month moratorium on multi-purpose loan and a 3 month moratorium on calamity loan. With regard to PhilHealth, the self-earning individuals and professionals which have been unable to, this applies to self-earning, unable to pay first quarter 2020 premium contributions over the counter, ACAS. The full reimbursement of hospital bills is very important for the COVID-19 patients from February 1 and April 14, 2020. There shall be a full reimbursement of hospital bills. But for the COVID-19 patients from April 15 onwards, yeah, they should be covered by a new case rate under the benefit package for all COVID-19 admissions. Now, these are the advisories issued by the SSS. These are flashed on your screens. The 3 month moratorium as well as to the pag-ibig. And the PhilHealth. Now, as I've mentioned earlier, at the start of my presentation, there is the Department of Labor through the POEA have recently issued this ACAP guidelines. No, ACAP is a one-time financial assistance of 10,000 pesos or 200 US dollars for land-based and sea-based overseas Filipino workers whose employments were affected by the COVID-19 global pandemic. No, this applies to the regular or documented OFW who are in possession of a valid passport and appropriate visa or permit to stay and work in the receiving country and whose contract of employment has been processed by the PUA or the POLO. Now, for the unqualified undocumented OFW who lost their regular or document status or who has not registered with the who are not registered with the POEA or whose contracts were not processed by the POEA or the POLO but have undertaken actions to regularize their contract status, and those OFW who are not registered with the POEA or whose contracts were not processed by the POEA or the POLO but are active OWA members at the time of the amendment. This also applies to the balik manggagawa or those who are unable to return to work or to return to host country in view of the host country's lockdown due to the COVID-19. Now, for them to be eligible for this ACAP, no, the following requirements must be present. For those who experience job displacements due to receiving country's lockdown, receiving quarantine, or having been infected by a disease, or who is still at overseas job sites in the Philippines as balik manggagawa, or is already repatriated to the Philippines, and who has not received any financial assistance from the receiving country or his or her employer. Now, flash on your screens are the application procedures. No, so the OFW shall submit to the POLO such requirements such as the accomplished application form, the copies of their passport or travel document, the proof of overseas employment, and the proof of loss of employment on account of COVID-19. And for FWs have become undocumented through no fault of their own, they should submit proof that their that the OFW is currently involved in an ongoing case. No, so after the submission, the POLO shall evaluate application within 5 working days and shall notify the OFWs on the status of his or her application within 5 days. Now, if the application has been approved, then the POLO shall release a $200 or 10,000 pesos through bank transfer or remittance. Now, for the OFWs who have been repatriated or balik manggagawa, they shall submit these forms, no, the accomplished form, the copy of the passport, the proof of overseas employment, and the proof of loss of employment on account of COVID-19. And after submission of complete documents, the repatriated worker shall the RWO shall evaluate the application within 5 working days and notify OFW of the status of his application within 5 working days. And if approved, the concerned DOLE regional office shall release the 10,000 through material remittance or peso net. That ends my presentation. Thank you.
Thank you for that, Attorney Mel. So let's entertain questions regarding the retrenchment topic from an anonymous audience. Attorney Mel, how do you file the retrenchment notice to DOLE?
Okay, there is an certain required form, no, to be filed with the Department of Labor for the such retrenchment. If I may allow, no, if I may be allowed, I will just flash on the screen the certain requirements. Yeah. This should be undertaken to prevent substantial loss, service of written notices to both an employee, payment of separation pay equivalent to 1 month's pay, and use of fair, reasonable criteria undertaken in good faith. When you say notices to both employees, there is no prescribed form, but so long as there should be notice for the employees. For the Department of Labor, there's a required form.
All right. Another question for Attorney Mel. To clarify, the last in, first out basis is approved criteria during retrenchment.
Yes, yes.
So from Ms. K. King, one of our employee would like to avail his paternity leave as his wife is about to give birth tomorrow. Shall we provide him the 14 days paternity leave with pay? Thanks.
Yes. The other mandatory leave for such as paternity leave and mandatory and the maternity leave has not been suspended during this period.
So from M. Berguburu, due to the ECQ, do we have additional time to declare the pregnancy of an employee to SSS?
Especially now, no, after this quarantine period. Yes, I believe so. No, I think there will be the SSS will be lenient with regard to the deadlines, especially during this period.
Sure. Back to retrenchment. Tony Mendoza would like to know if the retrenchment pay is tax-free.
I'm sorry?
The separation pay for the retrenchment, is it tax-free?
Under the current rules, no, this retrenchment is not tax-free. No? This is not tax-free. So applicable tax rates will be applied. No?
Attorney Mel, from an anonymous attendee, can a company file for retrenchment immediately, even without implementing remedial measures such as reduction of work days or work hours?
Well, the rules, according to the Department of Labor, if you are already employing or observing an FWA in your company and without the filing of notice, you are still required to file such notice, even if you are already observing such.
Okay. So as to Pag-ibig and PhilHealth premium, is there an extension of deadline for Pag-ibig and PhilHealth premium contributions payment for the formal sector?
Yes, there is an extension.
All right. All right, so let's proceed to our next presenter, Attorney Declaro. The rest of the questions, we will answer them during the Q&A portion at the end of this presentation. Thank you.
Thank you.
Hi, good afternoon, everyone. Just to confirm, do you hear me?
Yes.
Okay, so good afternoon, everyone. I'd like to thank all of you again for joining us today. I am Christine Declaro, a junior associate at GSMH Law, and I will be presenting the last topic of this webinar, which is COVID-19 Adjustment Measures Program, or CAMP. So let me share with you our slides on the topic.
Hi, hi. Uh, yeah, this is Mix Mejia. No, I just wanted to make a couple of clarifications on the questions just raised. Can you hear me?
Yes, sir, we can hear you.
Okay. On the taxability of retention pay in general, no, if it's involuntary on the part of the employee, any manner of removal, the separation pay for that would usually be exempt from taxes. And then with regard to extension for the formal sector for PhilHealth and Pag-ibig, the issuance made by the PhilHealth only covers the informal sector. It does not cover the formal sector, since most of the payment centers are still operational, no, and functioning. With regard Pag-ibig, there is no extension with regard to the contributions. But Pag-ibig has made announcements only with regard to extensions on the payment of loans by the employees, but we have yet to see any extension on the remittance of contributions. So that's it. Yeah, Kimi, please proceed.
Thank you,
Thank you for
Patricia.
Thank you for clarifying those questions. So let's proceed to CAMP. I will discuss with you the DOLE's COVID-19 Adjustment Measures Program. So what is CAMP? It is a program of the Department of Labor and Employment designed to alleviate the economic impact of the ECQ on workers who suffer income reduction due to the current pandemic. So under the CAMP, affected establishments are given an option to offset their employees' leaves of absence from their remaining leave credits. In turn, DOLE will assist affected workers whose leave credits have already been fully utilized by offering financial assistance and employment facilitation. But before I discuss the benefits of CAMP and the application process, it is important to highlight the following definitions to help us determine who may avail of CAMP and who are qualified to receive its benefits. So, affected establishments. Affected establishments are private establishments that implemented flexible working arrangements or temporarily ceased operations due to the COVID-19 pandemic. Second, affected workers are those whose working hours and regular wages are reduced due to the affected establishment's adoption of flexible working arrangements, or those workers who are temporarily suspended due to the temporary cessation of the employer's business operations. So there are certain employees who are excluded from the application of CAMP. These are employees in the top management, which includes the president, vice president, CEO, CFO, COO, executive director, board members of the board, and other persons having high-ranking positions. Also exempted from the coverage of CAMP are workers who do not have employer-employee relationship with the affected establishments. Now let's proceed to the benefits of CAMP. Why should you avail of CAMP in the first place? So first, a one-time financial support of 5,000 pesos will be given in lump sum to the affected workers by DOLE. This will be given as soon as possible after the submission of the documentary requirements. DOLE will release the financial assistance directly to the affected workers, either through their respective payroll accounts or through cash remittance if the payment is for cash payroll. So the next benefit is employment facilitation. DOLE will help affected workers find job opportunities that will suit their qualifications through job matching, referral and placement for local and overseas employment coaching, or labor market information. So before we proceed to the grounds for denial of application, let us first discuss the application process. So again, who may apply for CAMP? Affected establishments may avail of CAMP in behalf of the affected workers. So what the first requirement to avail of CAMP is to file an establishment report on COVID-19. This may be seen in the website, DOLE website, and this is attached to Labor Advisory number 12. So the second documentary requirement is the company payroll for the month of February or earlier. So when you don't have a company payroll for the month of February or earlier, the listed documents below may be submitted in lieu of that company payroll. These are workers' payslips, or a verifiable handwritten payslip, proof of payment of wages via logbook or ledger, employment contract, cash voucher or petty cash voucher, authority to debit account sent by the employer to the bank for the employees, SSS, PhilHealth, and Pag-ibig Alpha List or list of remittances, DIR form number 2316, or list of employees with 13th month pay. To clarify, you don't have to submit all the documents in the list. All you have to submit is the establishment report and any one of the documents I mentioned. These are the only requirements. These requirements must be submitted via email with the subject application for COVID-19 AMP to the DOLE Regional, Provincial, or Field Office having jurisdiction over your establishment. The list of email addresses may be found in DOLE's website and in the directory attached in Labor Advisory number 12, series of 2020. So after you submit those requirements, DOLE will process the application within 3 working days. After that, it will issue a notice of approval if it approves your application, or a notice of denial if it denies your application. So these notices will be sent via email as well. In case you receive a notice of denial, these are the possible grounds for denial: the applicant's ineligibility, misrepresentation of facts in the application, and submission of falsified or tampered document. So when you receive a notice of approval, the DOLE regional office, provincial, or field office with respect to financial assistance, again, will issue or will release the assistance to the beneficiary either to his payroll account or through cash remittance if the payment is for cash payroll. Afterwards, the DOLE will send a notice of completion to the applicant within 3 working days through email as well. So just to clarify, since there are 2 aspects of the benefits under CAMP, you may elect which one you want to avail of. If you just want to avail of the financial support, you may indicate that in the body of your email to DOLE. If you want to avail of the employment facilitation, you may indicate that as well. So in case you choose employment facilitation, DOLE will refer the workers to the nearest public employment service office, which shall then be matched according to their qualifications. So that's all for CAMP. Open to take.
Thank you, Attorney Declaro. Now we will entertain questions regarding CAP financial assistance from an audience. Does CAP assistance come into play, or is it owed if employees are paid at full salary at the duration of the ECQ? So to clarify, is it a matter of entitlement if an employee is under a flexible is under a flexible working arrangement and receiving salary, or is it not a matter of entitlement?
It depends. If he receives his full salary despite the implementation of the flexible working arrangement, then there is no need for the establishment to apply for camp with respect to that employee. However, if that employee's income is reduced due to the application of flexible working arrangement, then uh, the establishment should apply for camp.
Another question, is the camp application form submitted to DOLE for availing the financial assistance valid as a substitute for the company notice of work reduction status report form? Yes, attorney.
If can I answer that, Jeline?
Yes, go on, Attorney Mel.
Okay. There is a separate notice requirement for the camp and for the retrenchment and other flexible working arrangement. So to answer, it's not the same and it cannot be made a substitute for the notification requirement for the retrenchment. Thank you.
All right. All right. So from Miss Eileen Tolentino, what if we don't receive any notice at all, neither approved or denied? Can we follow up? If yes, how do we do that? This is with regards to camp financial assistance as well.
Sorry, can you repeat that?
So what if we do not receive any notice at all, neither approval notice or denial notice? Can we follow up? If yes, how do we do that?
It would be advisable to follow up through email as well. Resend your application again because there's a good chance that DOLE might have overlooked your application because of the number of applications coming in. So it wouldn't hurt to resend it.
Yes. How about temporary employees? Can they avail of the camp? Yes, Attorney Mejia.
In addition to that, no, they may call the hotline. It's 1349, or they can also email camp.doleble@gmail.com. So I'll get that information to you. Maybe you can post it. Thank you.
All right. All right. Thank you. Thank you for that, Attorney Mejia. So another question, can temporary employees avail of the financial assistance under the camp program?
As long as these temporary employees are employed by the company, camp may be availed on their behalf since it does not distinguish as to the status of the employee.
All right. Thank you. All right. So let's proceed to other questions not related to camp, to our earlier topics. We will entertain questions now from Noli Fragacha. What will be the legal accountabilities of an employer if there has been a COVID infection during the reduced or skeletal work scheme, even if all standard protocols have been practiced? Attorney Mel?
Can you repeat that, Jeline?
What will be the legal accountabilities of an employer if there has been a COVID infection during the reduced or skeletal work scheme, even if the employer applied all standard protocols?
Okay. If the employee was infected in relation to his work or her work, then the employer can be held liable under Employees Compensation Program of the ACC.
All right. So from Ms. K. King, we received responses from DOLE which says that the status of our camp application are approved and now on the official list of DOLE. However, some are on encoding or pending / follow-up status. Do you have any idea what this means?
Hi. Yes. These statuses, those mean that the information you you stated in the form are incomplete, or there are certain issues with your entries in the form. So it's better to clarify with the DOLE what they want you to do in order for them to completely process your application.
Alright. Attorney Declaro, if ever an employee just started working last March 12 to company B and he receives first salary for the 3 days he's working for the company, where should he claim for the camp? Where should he claim for the camp? From company B?
To clarify, well, he'll claim the camp from his current employer, but again, this financial assistance arising from the camp is actually from DOLE. So what the employer would only have to do is to apply on behalf of that employee. So I see no issue if this company will apply for that for that recently hired employee.
All right. From Mr. Freddy Alquiros, is it payroll for February or March, which is required for the camp? Which payroll, for the month of February or for the month of March? And yes, Attorney Declaro.
This is the company payroll required. Am I right?
Yes, for the
Yeah.
month of Feb or March.
They should submit the company payroll for the month of February or earlier.
All right. From an anonymous attendee, how about employers who did not file establishment reports during the opening of business? Can they still apply for camp?
Yes, they may still apply as long as they submit the establishment report for COVID-19 and the company payroll or any of the documents I enumerated earlier. They can still apply for camp.
Another question, Attorney Declaro. Are resigned employees wherein the turnover period overlaps the ECQ period entitled to camp? Can the employer include them on that report, on the report?
Just to clarify, they resigned during or their last day. Does it fall on one of the days during the ECQ? Did their last day fall during?
The turnover period overlaps the ECQ period. Only the turnover period.
In that case, if it's just a turnover period, then the employer no longer needs to apply for camp on their behalf because they're considered terminated. It's just a turnover process that's still going on.
So another follow-up question on the liability of the employer if the employee acquires COVID while he is under the flexible work arrangement, such as working from home. In that case, is the employer still liable, Attorney Mel?
Sorry, if the employee is what do you mean? The employee is under work from home and he.
Yes.
Okay, great. The only obligation of the employer in such is to report it to the Department of Labor and the Department of Health as well. He shall not be made liable for that.
All right. So let's jump again to camp. Just a clarificatory question. If employer who applied for camp gives full wages during the ECQ, is the company automatically disqualified?
Well, disqualified. Well, yes, because as we defined earlier, there only there's a limitation to the availment of camp. So only those establishments that enforce flexible working arrangements that lead to income reduction may avail of camp in their employees' behalf. But those who still pay their employees in full are not mandated or are not qualified to avail of camp.
So this is an interesting question from Ms. Rachel. Attorney Declaro, if there are only 2 employees among the 100 employees whose pay are affected since the company implemented work from home and the work and roles of those 2 employees cannot be converted into work from home, can the company still apply for for them?
Yes. If you see the application form or the establishment report form, you will be asked to enumerate only those who are affected or whose respective incomes are reduced because of the flexible working arrangement. So in that case, the company may apply for CAMP with respect to those 2 employees.
All right. So this one is from Kiara Taket. Just a clarification. Must the employee consume all leave credits first for him or her to qualify for CAMP?
Sorry, can you repeat that?
Must the employee consume all leave credits first before to qualify for CAMP?
Yes. CAMP only applies to those whose leave credits have already been utilized. So in that sense, their income has been reduced already.
Mm-hmm. So
Yeah, let me qualify that. No?
All right, Attorney Mejia, yes.
I think the basic qualification for camp is that there is a reduction in the income of the employee. Uh, so in cases of establishments where the employee opted not to avail of the leave credits, or the leave credits were not used by the employer, so long as there is a reduction in the earnings or the salary or the wages of the employee because of the COVID-19, then they would qualify for camp. In case of doubt, since it's the dole that's evaluating the applications anyway, we suggest that you just file, since there's no additional expense on the part of the employer. All of the payments are to be made by dole and not by the employer.
All right. Thank you for that, Attorney Mejia. So let's proceed to a question regarding the notice necessary for implementing flexible work arrangements. So from an anonymous attendee, what will happen if the business did not submit establishment report form with the DOLE? Attorney Mel?
I'm sorry.
What is the consequence if the business that adopted a flexible work arrangement did not submit establishment report form to the DOLE?
Okay. If the employer failed to file certain notifications, then the flexible working arrangement may be, I said, may be questioned later. No? It may also prevent them from availing of other benefits as well.
All right. So from M. Guru, during ECQ, can a company terminate a contract for reasons other than COVID-19?
Yes, so long as it is just and justifiable, the contract can be terminated.
All right, sir. So with regard to probationary employees, how about a probationary employee who was not able to work due to the ECQ, even though our company is operational? Will the probationary term still be extended?
Okay, it depends on the reason of his failure to report for work. No, if it's COVID related, then it may be extended. However, the principle of no work, no pay policy can also be applied. But if it's not related to COVID, then if the company continue to be in operation, then it affects the 6 month probationary status as well.
All right, sir. Thank you. From Miss Sabrina Azcarate. Hello, Attorney Mel. Does report of esta- is the report of establishment valid even after the listing of the ECQ? If business does not pick up, if the business does not pick up after the listing of the ECQ, can employers still apply the flexible work arrangement? So even
Okay.
after the ECQ period, sir.
Okay. Let me clarify those questions. So I think there are a lot of questions in that. No? If there, the employer can still submit the required form, no, for notification purposes. But if the for the FWA under this ECQ, the DOLE was clear, no, was very clear that this ECQ shall only be made applicable during this ECQ, these such FWAs. However, if and after the lifting of the ECQ, there is still business uncertainty, and the company there is after evaluating its status and still uh, and decides that there is still a need to avail of such FWA, they can still avail of such arrangement, but no longer under the labor advisory, but under the normal procedure or the FWA as provided under Article 301 of the Labor Code.
All right, sir. So this is just for going back to the flexible work arrangement. So this is from Chief. May I ask if the rotation of workers, reduction of work days means that during the ECQ we are allowed to go to the office?
No, no. If their establishment is not considered as essential, so even if they adopt such FWA or work from home, rotational, whether it's rotational or reduction of work hours, they are not allowed to go to their physical offices.
Mm-hmm. Is an employee working in a healthcare or medical industry allowed to refuse to report to work?
Sorry?
Is an employee working in a healthcare or medical industry allowed to refuse to report to work?
Well, if there is an imminent danger, as evaluated by the Department of Labor, then such refusal can be justified.
All right, sir. All right, sir. All right, sir, let's entertain. From an anonymous attendee, how about reduction of wages? Does this refer to a scenario where there is no overtime or go reduced wages?
And no, no, if so long as the employee rendered work 8 hours a day and for 40 hours a week, then there shall be no reduction of his salary.
Yes, sir. How about after the ECQ? If the employee will be infected, assuming that the employee started to work in the office again, what will be the obligation of the company?
Okay. If if after the FWA and the employee contacted this virus, he shall be required to undergo quarantine. So the same principle applies. Then this quarantine period shall be credited against his existing leaves. No? If, however, the leaves has already been used up, it's really up to the principle of no work, no pay shall be observed. However, the Department of Labor as well as the President has been asking and has been the labor sector that to uplift the status of these employees the employers are encouraged to grant additional leaves, with pay or without pay.
Attorney Mel, how about if you hired an employee and the date of hiring was the start of ECQ? Can you cancel the hiring date and move it into a later time when ECQ is listed?
If it's already provided under the contract, it can be moved to a later date after the lifting of the ECQ, unless there's a company practice or policy provides otherwise.
How about if, so this is a clarificatory question from an audience. Our latest payroll is for March 15. However, some of our employees have resigned after February 29. Should it not be the latest payroll? This is with regard to the establishment report.
So this is on camp, right? It is for camp.
Yes, yes.
Yeah. Okay, so for employees who have severed their employment before the ECQ, they are no longer required to be included in the establishment report. So the previous payroll, their payroll for February, while they still show the employees who have already resigned, the latter part of the report will require the affected establishment to list all of the affected employees. In such case, they no longer have to include those who have already resigned.
So this is addressed to Attorney Mel. In case employer is not providing OTs or allowances previously provided prior to the ECQ, will it be already tantamount to reduction of wages, qualifying the employee for camp?
Sorry?
So in case the employer during the ECQ did not provide OTs or allowances which are provided prior to the ECQ, is that already tantamount to reduction of wages, such as that the employer or the employee will be entitled to camp?
No, no. The non the camp. I think camp. No, I think Kindik, if you can clarify this. No, a camp can only be applied if for those affected employees, meaning those who have whose wages has already been reduced or affected by this because of this COVID-19. Then that's the only time that they can avail of the camp. If such employee is rendering work full 8 hours a day and is receiving compensation during this period, then he shall not be entitled to count, regardless of whether or not they have been paid of overtime pay before.
All right. So this question is from Mr. Alquiros of ASSI, Attorney Declaro. What are the real requirements for filing online for the camp? Latest payroll or latest two payroll?
As I stated earlier, the requirement is only the company payroll for the month of February or earlier. Or in lieu of that, you can submit any one of the documents I mentioned.
If I may also add to that, no, I think the reason of requiring the submission of the payroll is to determine the latest monthly payroll of such employee. So I think that qualifies it.
All right. So how about a business permit, Attorney Declaro? Is it required for filing applications for camp?
No, it is not required. Again, based on the labor advisory, there are only two requirements for the availment of camp. First is the establishment report on COVID-19, and the other is the company payroll.
Mm-hmm. All right.
So any document other than that is
no longer required. All right. So this is addressed to Attorney Mel. So this is from MedKismet. Currently, we are implementing work from home arrangements. Here are my questions. How are we going to sanction those bottom performers during this work from home arrangement?
Okay, no. I think the importance of prior consultation before the effectivity of the FWA comes to place now. No? If there has been a clear policy imposed upon by the employer that even if you are working from home, you have to meet certain guidelines, certain criteria, and for your failure to meet certain criteria, then you can be sanctioned. No? However, in cases you have to determine the causes of such poor performance. No? If the poor performance came from the failure to render work because of the COVID-19 related, then the employee cannot be made held liable or can be sanctioned because of that.
Okay. So, Attorney Mel, can we execute, in line with that, can we execute digital procedural due process? By that we mean, can we send notice to explain or notice of dismissal online through email during this ECQ period?
Okay, so long as the causes or the offenses imposed is justifiable, meaning as provided in company policy, the only requirement of the law is that the employee should receive or should receive such notice to explain. So you can, in the meantime, you can send out notices via email so long as you can show proof that the employee actually receives such notices or admin sanctions.
All right. So this is from Miss Daisy of Asian Terminal.
Ja,
Can
yeah.
yes, Attorney Mejia, yes.
Just to add to that, so you can still do your disciplinary actions for just causes for termination. Just be mindful of the two notice requirement, the time period to explain, which should be 5 days, and then the admin hearing. I think among all the requirements, it's the admin hearing that's most difficult to comply with at this time. No? Uh, if you can do a telecon or if you can do a video conference, then that would be good. Uh, I say that the admin hearing is very sensitive because if there is evidence that you need to confront your employee with, you have to do it during the admin hearing. So in lieu of doing that during the admin hearing, perhaps you can send it by email before.
Right. All right. Thank you, Attorney Mejia. So, Attorney Mel, this is from Miss Daisy. Can I have further clarification on this question? Do company do company do companies need to pay salary of employees who are PUI or PUM and on leave?
Okay, for those PUIs under PUI and under PUM and COVID positive, is that what you're referring?
Yes, yes, sir.
Okay, then they shall be uh, placed under quarantine. Then those period, again, as I mentioned earlier, that period will be credited against the existing leave credits of the said employees.
Okay. So this is a question from Mr. Fedilin. So we are in the food and beverage industry, and we foresee to be only having a 40% labor if we will be restricted to delivery and takeout only. Attorney Mel, what are our options for the rest of the 60% employees? We have three categories of employees: regular, probationary, and those under agency.
Okay, is this after the ECQ?
Yes, during the ECQ and after the ECQ.
Okay,
While the
again,
law
as I mentioned
requires.
earlier, if during the ECQ,
All right.
okay. If during the ECQ, the flexible working arrangements can be can be observed by the employee, hence the rotational type of status. They can only identify such employees who can be required to report for work so long as the notification and the legal process has been observed. After ECQ, they can still opt to observe the FWA so under the labor code provisions.
All right, sir. How about this, sir? What is, no, this question is from
Yeah,
Mr. Noel C.
I add to
Yes,
that. Sorry.
yes, Attorney Mejia, go on.
One in the food business, uh, with regard to the 60%, if you can, it is also possible during the ECQ period, if you want to expand your operations, you can reassign some of your employees to add to the 40% that's currently working. No? Uh, Meaning, if you wanted the waiters to do deliveries, you can also do that. I think the ECQ provisions would allow that. It's just I think the administrative burden, the additional administrative burden would just be to get different IDs or issue new IDs to these people.
All right, sir. All right, thank you. Attorney Mel, this is from CAF. How about project hire employees? Can we terminate project hires during the ECQ since the project was already suspended and there is no assurance that the project will resume?
The FWA, as expressly mandated by the Department of Labor, applies to all types of employees, whether they be contractual, uh, probationary, or regular employees. So it can be applied to project employees as
So, but how about project hires, sir? Can they dismiss the project hire employees, considering that the project that they were supposed to report to is already suspended and there is no assurance that the project will resume?
I think for project employees, for projects that are in limbo now, um, you don't have to terminate the employees. You are allowed to put them on floating status for up to a period of 6 months. It's very risky in terms of risk. It's very risky to terminate them now because if there's a especially if there is a possibility that the project will resume after the ECQ. So terminating the project employees now might be premature. What you can do is to inform your employees that the project is suspended and that they're not required to report to work. And you have 6 months to keep them in this status. If it becomes clear before that 6 months, then you can terminate them. Or if you're able to reach the 6 month and there's no resumption of the project, then you can terminate the project employment. But don't do it now, especially when it's not yet clear that the project has been terminated.
Mhm. Yes. All right. Thank you for that, Attorney Mejia. So, ladies and gentlemen, since we have time constraints, we will only entertain two more questions before we wrap up. We are also available for follow-up, or we can entertain all your personal questions by emailing us. But right now, for our last two questions, this is from anonymous attendees. Attorney Mel, for the FWA notice, does this need to be filed 1 month before the effectivity or only 1 week due to the COVID situation?
I think these notification requirements has already been clarified under the Labor Advisory Number 12, 2020. I think it was issued in realization because of the under the Labor Advisory 9, there is a 30-day notice requirement. This has already been dispensed with, and you can already file ASAP so long as the 1 week prior notification of our effectivity of the FWAC is observed, and that's it.
So, all right, sir. All right. For our last question, mm, for our last question. So is it true, Attorney Declaro, is it true that the camp is it true that DOLE will prioritize SMEs for the camp financial assistance program?
As of now, I don't think I think they want to prioritize them, but I think they are paying off or releasing funds as they approve applications. So I think with the number of applications they're receiving right now, it does not necessarily translate to the release. However, that's what they want to do. They want to prioritize SMEs.
All right. So again, thank you everyone for joining us today. I'm sorry if we could not entertain all your questions, but we managed to answer majority of them. So if you have further or follow-up questions, please email us at the email address that's flashed in the screen. So for Attorney Melchor Manalo, melchor.manalo@psmhlaw.com. And for Attorney Christine Declaro, christine.declaro@psmhlaw.com. So please also watch out for our next webinar, which will include discussions on corporate issues and tax issuances. This is the title of our next webinar, Clearing the Air, Helping Businesses Navigate COVID-19 Relief. Thank you again for joining us today. And we wish to see you at our next scheduled webinar. Thank you. Also, please be reminded that we will share with you the materials that we have presented today, including the forms that are necessary for applying for CAMP and for the reportorial report for implementing FWAs or flexible work arrangements. Thank you, everyone.
Thank you.
Thank you.